edit, but I know it was just one sentence.
3 words, and I don't care about the 3 words he changed. So.
Well, I was going to say I was somewhat leading towards Mr. Elligott's change. So if you're not opposed, then let's just go with Mr. Elligott's change. Ms. Crowells, you asked for reconsideration on 2 issues with respect to Dr. Newberger, and then you wanted to add a 3rd. Let's deal with that first.
Okay, thank you.
Meaning, let's do the 2 reconsiderations, and then we'll.
Right, I don't know if it was helpful, Judge, I sent you just the run report of what's being read in, and it had those, so that you wouldn't have to try to find the deposition, but.
Yeah, I brought the depositions.
Okay, so the first one is, this is with the March, what's the date? March 24, 22 deposition. And it starts on page 11, line 18, as far as the answer. And the question was just, what are your opinions? The specific objection is to his commentary that starting on line 22, backing up, virtually all principal diagnostic medical judgments and decisions to Sally Smith was an intentional act, which was both wanton and malicious. And that goes on to say, on line 12, who together agreed to commit an unlawful act and harm other individuals. So we're objecting to the words intentional act, which was both wanton and malicious, and we're objecting to commit an unlawful act. I understand his comment. He's previously testified or subsequently testifies about this conspiracy thing, but those are the concerns, Judge. And then there was one other one.
Well, let's deal with this one first.
Sure.
Any response from the plaintiffs?
Your Honor, I have not seen it, but I do remember it. If somebody could read the line.
Here, do you want to share my paper?
Yes, please.
This is the run report from your area. I emailed last night regarding this.
It seems as though she is responding to the inquiry of what her opinions are, or his opinions were at that time there, Judge, and he continues, as the court probably noted in reviewing, to explain why he holds those opinions. Further, battery and false imprisonment would seem to qualify within what Dr. Newberger is expressing at that point.
Judge, I think that's ultimately the jury's determination as to whether or not it was wanton and malicious, or whether or not, and I don't think he's qualified to say whether it's unlawful.
90.704 states specifically that an expert may testify as to any of the ultimate issues in the case.
Okay, this is what we're going to do. At
703.
line 22, we're going to redact was an intentional act which was both wanton and malicious, but we will leave in the prior phrase, virtually all principal diagnostic medical judgments and decisions to Sally Smith. We will also excise, starting at page 12, line 3, this is by definition, all the way down to line 6, constitutes a conspiracy. So we'll leave in that's opinion number 1. So it will read, I intend to opine that this so-called team representing a group of individuals who together agreed to commit an unlawful act and to harm other individuals, period. That's opinion number 1. The commenting on the deposition and is not appropriate. Okay, so that takes care of your first request for reconsideration.
Yes, there's another on that
Go
same
to page, is it 14?
It is page 14, Judge. And it's line 22. It's in the middle of his answer. which this team cruelly, with no sympathy, with opacity of sympathy. Those are the words that were objected to, Judge, for the same reasons. Improper opinion.
Can I see it quickly?
Oh, sure, sorry.
Show me. Well, I think we got some grammar problems first, but leaving that aside. Well, analgesic medication, and then, and you're objecting to cruelly with no sympathy with opacity of sympathy.
Correct.
I would agree, Judge, to which this team cruelly and with no sympathy, and then, but I think with opacity of sympathy, and is non-objectionable. That's a description based on the punitive damages that are in the case. Obviously, we would move to keep all of it in light of the punitive damages, but if we are to, if the court is so inclined.
What does with opacity of sympathy actually mean?
Well,
I don't
that's why I
know,
don't think
given
it's-
what he said earlier in the sentence, I assumed, I didn't look it up, but I assumed, given what he said earlier,
I
that
believe-
it actually meant the same thing as with no sympathy.
a lack of view of sympathy is, I believe, one of the depositions. Well, a lack of clarity or view of, off the top of my head.
Well, I'm gonna strike which this team cruelly with no sympathy, but I will leave in with opacity of sympathy.
Okay.
Okay, and then what was the other one, Ms. Crowell? It was a different deposition.
Yes, Your Honor. The September 22nd, 20 deposition, this one's being read in, we missed an objection regarding standard of care of Sally Smith.
Yeah, I'm on page 150.
150.
I'm trying to look at your notes.
No. Line 4, starting with the word but. He answers the question, by the way, with to the contrary, because the question was, are you a CRPS expert? But then he goes on to give an opinion regarding Sally Smith, and given the fact that he's talking about child abuse pediatricians.
Anything, Mr. Anderson? Because I've been consistently excising that type of language from his opinion.
I just missed it, Judge, when I saw.
As to the deviations of Sally Smith, Your Honor,
Or he's calling himself a child abuse expert, or a child, this is not an expert on child abuse pediatrics.
May I inquire, Your Honor, is that based on the record in the depositions as to his background training experience? Because he is known generally in publications.
Dr. Newberger, and this is what I was excising from him, and I took out, I think, all of the references, because he kept talking about the dependency court and the concept of Sally Smith doing stuff for the dependency court. So I consistently have been taking that out. So I will grant Ms. Crowell's motion and remove on line 4, starting at page 150, starting at line 4. But I am an expert all the way through the conclusion of line 7.
Your Honor, can I have one comment?
Sure.
Which is, Sally Smith was, again, the child abuse rotation director within the hospital in her various roles. And described by some of the physicians there as the hospital's child abuse expert. So we think it's a fair comment.
Unless Sally Smith is not going to be allowed to testify in any way, shape, or form that she was a child abuse expert. Dr. Newberger's background training experience far exceeds Dr. Sally Smith's background training and experience in this regard.
But to the extent that Dr. Sally Smith was acting to collect evidence for DCF and the dependency court, there's immunity under Chapter 39, so I'm going to stay with my ruling.
I hope that ruling does not include the period of time between the 7th and the 9th, when there was no.
I'm only calling balls and strikes on what was actually presented to me, so
Thank you, Judge.
I honestly did not read if there was not an objection. I mean, I would have read a couple questions before so I had context, but I didn't go through and read what.
It wasn't even a response to the question, Judge. You just threw it in again.
With Dr. Newberger, I can see how it was very difficult to keep him answering the question.
Hence our request for the court for a bit of leeway with Dr. Newberger. I would have kept him significantly, and I'm sure the court, the defense counsel would have kept him significantly more focused in the answers. The plaintiffs cannot help what happened.
Yeah, it's okay. Well, let's just kind of move on to the next issue. Was there anything on the we didn't need any exhibits, or have there been any further movement on the exhibit list?
Oh, I'm so sorry. Can I have 1 second to tell
Sure.
what needs to come?
Worked on, may we inquire from the plaintiff in terms of the order of the witnesses?
Beginning with Jessica Blackrick, the guardian ad litem this morning. And then after that, we would play Sally Smith. I don't believe, I wasn't here from the very beginning. I don't believe we have any further revisions to her deposition, the rulings that were just made. And then so that would make sense to play her first. And then Dr. Newberger, so we can work on these revisions.
There was no discussion about Dr. Sally Smith's deposition.
All right, so she'd be second, Newberger third, and then Jack, Kyle, Maya. I don't know what the order is.
I likely will call Kyle, Jack, and Maya in that order.
Thank you, sir.
Okay.
Mr. Whitney, we did have a couple of minor edits that we floated last night.
Question was missing here and there.
I sent them to Ms. Lawrence last night. She asked for me to send them over, and I did. It was a few minor revisions.
I know that we made a couple of revisions at 7 o'clock or so. I don't know if there were more after that.
No, it was just one.
Well, I think I sent two. There was 5 volumes. I think I had one issue on one volume and one on volume 3. But they were all sent to Ms. Lawrence.
Well, I recall one was an objection that was raised last night that was not made to the court or something.
That was.
Not Newberger. There was something with Sally Smith as well that.
There was Sally Smith, I believe there was just, it wasn't a huge deal. It was, there were a couple of passages of assertion where there was a question missing, or there was context missing.
Looked like something got chopped early, is what it was.
And there was also a couple, and I sent them to Ms. Lawrence again, a couple situations where our light blue counters were not included in the video as well. But we're talking about a couple of things there.
Any substantive?
I sent them to Ms. Lawrence approximately 2 hours after we received the final edited version.
Not questioning the timing. I'm just wondering how we deal with it right now.
I can re-forward you the emails to Ms. Lawrence if you'd like.
I think we can make the corrections if they are agreed upon and do it during the witness's testimony. First, Ms. Blackburn.
We'll do our best.
Anything else that you need from me, or are we ready for the jury?
Your Honor, we don't really need to discuss, but to keep in the back of the court's mind before the Kowalskis go on, we had 2 demonstrative aids. One is a photo 2528.6 of Viana as a teenager, previously been submitted. It's for the purpose of damages, and it is not cumulative as to that.
Okay. If we're not going to deal with it right now, then let's not deal with it. Looks like Miss Lawrence is here now.
Apparently there's a couple
Oh, thank you.
David wants with this house.
So we're good now? Or,
Yes, we're going to make the correction.
okay. May I bring in the jury?
Yes, sir.
Okay, let's bring in the jury. I thought you were.
Jurors entering.
Okay, everyone, please be seated. Good morning. Very loud and energetic. Is that because we're getting close to Friday? No harm in asking, right? Well, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And while you were not with us overnight, you did not observe any sort of media stories about this case. Is that correct? Correct. And were you approached about this case at all? No. Okay. With that, Mr. Anderson, or Mr. Whitney, or who?
My name is called Jessica Blackrick.
She's outside.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Morning.
Morning.
Would you please state your name for the record?
Jessica Blackrick.
Have you been called here this morning to testify as the guardian ad litem for Maya Kowalski during 2016 and the very beginning of 2017?
Yes, sir.
First question is, would you please explain to the jury what a guardian ad litem is?
We are there for the best interest of the child. So in a dependency proceeding, the court can appoint a guardian ad litem where we're not for the parents or for the state. We are an independent advocate for the child's best interest. And specifically for Florida's guardian ad litem program, we're part of a three-pronged team where there's a child best interest attorney, there's the child advocate manager, which that's the role I was, and then there's also a volunteer guardian ad litem.
Is it fair to say that the guardian ad litem, your position, you're there as an advocate for the child?
Absolutely.
We'll talk about some specifics of your interactions with the Kowalskis in the hospital during this time. But before we go there, would you just briefly describe your educational background?
I have a bachelor's degree in psychology, and that's an associate's degree in liberal arts. That's it.
All right, and approximately what year did you get involved with the guardian ad litem program in Florida?
In 2016.
And how long did you work as a guardian ad litem in Florida?
I was about 6 months. I worked in the Third Circuit, which is Live Oak and Lake City, Florida. And then I transferred to Sarasota in July of 2016.
And you worked in Sarasota and that circuit for approximately 4 years?
Yes, August of 2020.
And After that, where did you move or go to work?
I moved to Waycross, Georgia, and I worked for a domestic violence agency for several years. And in May of this year, I took on the position as program director for CASA, or Southeast Georgia CASA, which CASA is Court Appointed Special Advocates. It's very similar to what guardian ad litem is in Florida. The only differences were not where we provide all the funding ourselves, but we follow the similar national curriculum that's called the National GAL CASA curriculum for everything we do.
So, when you were in Florida, you served as a guardian ad litem.
Yes.
And in Georgia, did you take on a more managerial role?
Yes.
Can you explain that to the jury, please?
I'm the program director, so I actually do have some cases where I'm the CASA advocate just because I never want to not be doing that. But for the most part, I supervise the entirety of the program and I write grants so that we can be funded.
With all that in mind, is it fair to say that you've been involved in this type of work, child advocacy, guardian ad litem work, for the past 7 or 8 years?
Yes.
Let's move to your specific interactions with the hospital and Maya Kowalski, Beata Kowalski. Were there occasions on which you supervised phone calls between Beata Kowalski and Maya Kowalski?
Yes.
On how many occasions do you think you did that?
Either 2 or 3.
Have you had an opportunity to review the court order that was in effect for that time frame?
Yes, sir.
Is it your understanding? What is your understanding about who was appointed to supervise phone calls?
Myself and the case manager,
Who was the case manager?
Charlotte Laporte.
And how long did you work with Ms. Laporte?
Well, at that point, since July of 2016, we probably had some random cases together.
All right. So, if I understood your testimony, there's 2 people appointed to supervise these phone calls.
Yes.
Either yourself or Ms. Laporte.
Yes.
Was there ever a time that you would supervise these calls simultaneously with Ms. Laporte?
No.
Is it fair to say it was one or the other?
Yes, that was the point of adding me, because normally we weren't appointed to actually be supervisors of phone calls. We would just be observers, but the judge in this case did do that.
All right. Did you ever delegate your responsibilities or authority to anyone at the hospital to supervise those phone calls?
Sure. The objection is overruled.
I'll re-ask the question. Did you ever delegate your authority to supervise these phone calls to Catherine Beatty or anyone at the hospital?
No, sir.
Let's talk about the phone calls you did supervise. Can you explain the framework, the setup of how these phone calls occurred? Where were you? Where was Maya? Where was Ms. Beatty if she was involved?
Okay. I was remote in Sarasota and in my car specifically because that was the quiet space that I could find. And I had to call in to these through the hospital. And so it was facilitated through Ms. Beatty. And she was with as my understanding.
All right. So participants on the phone calls then, again, would be yourself, Ms. Beatty, Beata Kowalski, and Maya Kowalski.
Yes.
I'd like to play for you what's in evidence. Have you had an opportunity to review some of these phone calls?
Yes, sir.
All right. We have bits and pieces in evidence. I'd like to play for you what's already been admitted as 2608 alpha, and it's about 1 minute and 10 seconds.
Okay.
Okay, I'm recording this phone call so everybody knows. Okay, hi mommy. Hi honey, how are you, sweetie pie? I'm hurting, I miss you. I miss you so much too. I miss you so much every day. Every single day. You know how happy it makes me feel to hear your voice. Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice too. Yeah. I hope you. What did you say, sweetie? I hope I can see you soon. I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay?
Beata?
Yes.
Beata, we're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Do you remember that call?
Yes, sir.
Oh, was that you interrupting the phone call?
No.
Was that Miss Beatty?
Yes.
Beyond that October 15th call, did you have additional phone calls? Were you supervised?
Yes.
Was Ms. Beatty present on those calls as well?
Yes.
Do you recall from the order any limitation on how frequently phone calls were to be facilitated between Beata and Maya?
Same objection, and also in terms of foundation and time.
Why don't you deal
Sure.
with the time
Sure.
issue, but otherwise overruled.
All right. Do you recall that you supervised several phone calls in mid to late November?
Yes.
All right. The court order in effect at the time, having reviewed that court order, was there any limitation placed on the frequency of the phone calls between Beata and Maya that were allowed?
No.
Was there any limitation imposed on the length of those phone calls?
No.
Did you make yourself generally available to facilitate phone calls as the supervisor under the order?
Yes, sir.
Do you recall a time that Beata had requested a phone call on Thanksgiving?
Yes, sir.
Did you make yourself available?
Yes.
Was that phone call allowed to happen?
No.
Why?
Because Miss Beatty's schedule didn't allow for that.
So Ms. Beatty was not amenable to a phone call on Thanksgiving between Beata and Maya?
She just wasn't. It just wasn't in her schedule, from what I know.
All right. Do you recall a phone call after Thanksgiving?
Yes, sir.
Have you had an opportunity to listen to that phone call?
Yes, sir.
If that phone call is allowed to be played for this jury, do you consent to the playing of that phone call?
Yes, sir.
In that post-Thanksgiving phone call, did Beata Kowalski attempt to pray with her daughter?
Object
Yeah.
to the hearsay, Your Honor.
I haven't asked for it.
Overruled.
Did Ms. Kowalski attempt to pray with her daughter?
Yes, sir.
What was Ms. Beatty's reaction to Beata trying to pray with her daughter? If you could explain that to the jury, please.
Well, the phone call was, Miss Beatty had mentioned that the phone call it was time for the phone call to end it because she needed to go to a meeting. And Ms. Kowalski asked to pray or began praying. And then at one point, it was interrupted by a lot of loud noises. And Ms. Kowalski asked what the noises were. And Ms. Speedy said that it was her office stuff. And anyway, she proceeded to finish the prayer, and then the visit ended. And afterwards,
Let me stop you right there.
Sorry.
You're doing great. I just wanted to clarify, when you say the visit ended, does that mean that at that point, after the prayer, which was slightly interrupted, that Maya and Beata both hung up?
Yes.
So at that point in the phone call, it was just Ms. Beatty at the hospital and yourself.
Yes, sir.
All right. Please continue.
So at the end of the call, Miss Beatty said to me that that prayer was just the mom's way of extending the phone call. And I said, well, she has a right to pray. And then we were going to schedule, I asked her, can we schedule the next phone call? And Miss Beatty said, no, we're not going to schedule anything right now. I'm going to end the phone calls at this point. I'm going to take care of that.
And as part of your training as a guardian ad litem, do you receive training on the right of families in these types of situations to maintain their religious practices?
Yes, sir. There's cultural competence training that includes all different aspects, including religion. And it's part of our goal as guardian ad litem to make sure that the child is having all of their normalcy needs met, and that includes any kind of religious practice.
And did you inform Catherine Beatty of this, the right to practice their religion?
Yes, it was a quick comment, but I did say, well, she has a right to pray.
And after Ms. Beatty stated to you that she was going to put an end to the phone calls, did you have any future phone calls where you were allowed to supervise Beata and Maya speaking?
No.
Your witness.
Good morning.
Good morning.
Just a few questions for you. So, if I understand, I think I understand, but so the jury understands the role. The guardian ad litem program is the neutral appointed in the best interest of the child. True?
Yes, sir.
Okay. There's training that you go through. And then there was also somebody who was, I think you said, a volunteer that was assigned as well?
Yes, sir.
Okay. Do you remember who it was?
Yes, Sharon O'Leary Johnson.
Okay. And she would be someone working, is she working under you?
Yes, so I would be her supervisor.
Okay. And she reports to you, well, let me set the preface. I know you and I know what's going on, but I think for the benefit of the jury, let's sort of explain the role. So you would go to the hospital and visit when you could, right?
Yes.
And Miss O'Leary Johnson, as the unpaid volunteer, would also go as well, right?
Yes.
And they would file their observations of what they saw in the hospital in reports.
Correct.
And you would do that as well?
Yes.
Okay. You're not hired by All Children's. You're not paid by All Children's, right?
No, sir.
And you're not paid by the Kowalski family.
Correct.
You're the true neutral.
Yes, sir.
Okay. And not to say you would do anything else, but actually you guys have to sign an oath to the court that you are going to advocate only in the best interests of Maya, right?
Yes, sir.
Okay. And you make recommendations to the court based on what you see as well, true?
Yes, sir.
Okay. So let me ask you a little bit about, have you reviewed your notes?
No.
Okay.
One.
Got it. All right. So if you need to refresh your recollection, let me know. But do you recall that you first visited Maya at All Children's Hospital on October 14th?
Yes.
Have you reviewed that note?
That's the only note I reviewed.
Okay. If you need me to, would it be helpful to have the note in front of you to refresh your recollection?
Yes, that would
Okay. May I approach, Your Honor?
You may.
And I do have an extra copy for plaintiff's counsel. Okay. So what I'm going to hand you for the purposes of identification is going to be Defense Exhibit 3250, pages 1 through 4. And I'm glad you have your glasses on because the type print is very small.
Yeah, I'm actually gonna have to take them off for that. Just that's first thing probably.
All right. Do you want to take a moment to read that one? Would it be helpful before I ask you questions?
Okay, that's fine.
Okay. So this note is computer generated by you, correct?
Yes,
And it shows in here that the date of the visit that you made to All Children's Hospital was October 14th, 2016, right?
yes, sir.
And it says that it was a face-to-face meeting with Maya, correct?
Yes,
And it says that the meeting was about an hour and a half, is that right?
yes,
Okay. And then you made some notes on your meeting, right?
correct.
Okay. In your note, where was Maya at that time?
She was, let's see. Yeah, she was in her room, her hospital room.
Okay. Did the hospital ask you to come to the hospital and explain to Maya why she was being held at the hospital?
Yes,
Okay. And just for frame of reference, on October 14th, earlier in the day, you were at the dependency court, correct?
correct.
And you made a note that the Kowalskis did not contest shelter at that hearing, correct?
Approach both of you, please. Disregard that last question. It's not relevant to this case at all.
You were asked by the hospital to come to visit Maya and explain to her why she's staying at the hospital. Is that right?
Yes, sir.
Okay. You made some observations while you were at the hospital. Is that fair?
Yes, sir.
Let me ask you about a couple of the comments in here. May I approach on a question before I ask it, Your Honor?
Yes. Okay, members of the jury, I'm going to ask that you step into the other room for a few moments. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All rise. Jurors exit.
Okay, the jury is out of our presence. Ma'am, can I actually have you go sit out in the hall for a few moments? Okay, the witness is out of our presence, so is the jury. Mr. Anderson.
As we explained to the court above, and again, for the record, by virtue of counsel having taken a DCF note, held it up.
My apologies. I know you're not. I'm just moving them so you don't. Sorry, Mr. Anderson. Go ahead.
By holding it up, showing it around the courtroom to the jury, referencing it as what it is, and then reading out sections. Admittedly, as we watched, yeah, there's some slight paraphrases, but in essence, the language of that note was being portrayed then to the witness. And in that way, the jury is now under the impression that there are notes out there that are contradicting everything the witness says and introducing the whole idea here, the concept of who was in control at what point, which is in direct violation of this court's instruction that we are not supposed to be getting into that stuff. And the plaintiffs have been chastised, and I understand the court's position on those. But in this instance now, we have got effectively a published, or at least part of a published note in here on something the court specifically instructed us, the plaintiffs, and the defense was there not to do. And so we asked the court to take under advisement, because obviously with 5 years into this, we want to see a jury verdict here, but we asked the court to take under advisement a motion for mistrial in that regard. And we asked the court also to consider, if indeed this is the way they're proceeding, and at this point that the door has been opened for us to attack some of these notes and some of these positions and some of these actions that were behind the orders and DCF directions. So that is our position.
Well, let me be, are you or are you not moving for a mistrial? I need a clear, you are or are not moving for mistrial.
May I inquire from the court, if I may move as previously done here, to move for a mistrial, but have the court take it under advisement until the conclusion of the case, because I do not want to take a step right now that wastes 5 years of litigation and now 3.5, 4 weeks.
I am not in the position to give an advisory opinion about what I might do on a motion you haven't made.
Then I cannot make it, because I do not want in any way to have this trial.
So to be clear, you are not moving for mistrial.
Under these circumstances, I am not moving for mistrial. I am, however, documenting for the record that the extent of the damage done here is a basis for it, but I cannot move for a mistrial at this point based upon the circumstances of this case and a disservice to my client after all of this effort. So I just want to say that for the record.
One comment, if I might. There was a representation made to the jury about the Kowalskis not contesting the shelter petition, which is damaging. There was additional representation made that comment was made because something in this note comments on that. I've reviewed the note again. There is no commentary in this note on the failure of the Kowalskis to properly contest that shelter or consent to that shelter, however you want to phrase it.
Well, first off, is this document in evidence?
It is not, Your Honor.
Okay, let me see this document. Just put it. What's the number?
It's Defense Exhibit 3250-001.
And can you make that note bigger so I can read it? Mr. Shapiro, I thought the question was, now maybe we can have the court reporter ask it again or read it back, but the comment or the question that you asked, which was not, I don't believe it was answered, and then ultimately I gave an instruction for them to disregard, was something about her note indicating that the Kowalskis consented to the shelter proceedings at that court hearing.
I believe I asked, well, anyway, go ahead.
Can we have the court reporter read back the question that right before we went to sidebar that started all of this?
Yeah, give me just a minute. Scroll up there.
That's why I did.
Okay, question, and did you, dash, and you made a note that the Kowalskis did not contest shelter at that hearing?
Was there an answer by the witness?
Yes, at the same time as the objection.
I apologize, Your Honor. It was because her note says that she had just came from the hearing. I was trying to set the table, and I thought it was because the plaintiffs opened the door to the orders, the interpretation, and the no contact that was entered. That was the purpose for going through it. I will stick my questions for this witness only to their observations at the hospital going forward. It was completely unintentional to make that reference, although with the way the plaintiffs have opened the door to this throughout the trial. But all that being said, I apologize for the comment if it was made out of context, and I will stick to our observations at the hospital. If I may, since I don't want to step in any more hot water on this, the plaintiff did.
I don't understand how that question was asked based on this note.
I understand.
And given the nature of the defense, let's not talk about the dependency. Let's not talk about the dependency. For years, let's not talk about the dependency. You misrepresent a note on a question that you know can't be asked.
My apologies, Your Honor.
Okay. There's no motion for mistrial. So
we'd like to discuss with our appellate counsel what an appropriate curative instruction would be if we can come up with one.
And also, we were trying to document for the record the seriousness of this, but we're aware of the second district law on the necessities here. We're in a box. We would ask the court's indulgence to give us the opportunity at some point in the very near future to discuss this with Mr. Tanner, Mr. Elliott, and determine what the best approach is, and also our clients who are not in the courtroom at this moment. At least I don't think they are. And so, but now that the jury thinks that we're consenting to all this, I can't imagine anything more damaging.
Well, I will give you time to discuss with Mr. Elliott and your clients what we're going to do. My suggestion at this point, and maybe you need to take a couple moments, is that we just continue on. Again, to be clear, the plaintiffs have not opened the door by talking about whether there was that delegation in the specific time. I know you disagree, but that's the court's ruling.
I understand.
And you have to live with the court's ruling. So you can't.
I humbly apologize, Your Honor. I believe they had opened the door by talking about what the order said, who was responsible, who was allowed to contact who. But I apologize.
As a reminder, I mean, we've been, and I know you weren't there for so many of the hearings, and you kind of came in to this late, but we always talked about, before you do something that is possibly out there on an edge, come talk to me ahead of time. You didn't do that.
I agree, and I did it the second time. So before the witness comes in, just so I don't step in it again, there are 3 notes written by the guardian ad litem regarding their observations of Maya at the hospital. May I inquire of this witness what the observations of the guardian ad litem were? And then at the end of
Absolutely, at the hospital, sure.
Yes, and then just again, so I'm approaching this, I'm treading as gently as I can, Your Honor. At the end, there's a guardian ad litem report to the court. Can I phrase my question in terms of, well, let me ask Your Honor this. The report is titled Recommendations and Observations of the Guardian ad litem.
Do you want to start talking about the dependency action? Does the defense want to talk about what happened in the dependency action?
No, but that's why I'm asking you, can I ask this witness about what the only the part about in the report, and I'm happy to hand Your Honor a copy, because again, I want to make sure I don't, and there's an extra copy for plaintiff's counsel. There's a section on
Can we put this up and just
yeah,
make,
sure.
make
It's
it
Defense
bigger
Exhibit
so I can-
3258-001.
3258-0001, and this is not in evidence?
No, Your Honor.
Okay, and what provision do you want me to look at?
Section 3, Observations of the Child.
Can you make that larger? Okay. This looks like an observation that was made at the hospital.
Correct, Your Honor.
I have no problem with you asking what this witness saw, what she saw of Maya at the hospital. If she doesn't remember and she needs something to refresh her recollection, certainly you can refresh her recollection with this, but it's not going to be shown to the jury.
I understand, Your Honor. That's why I brought extra paper copies.
Well, Your Honor, this is a pleading to the court. We previously had a lengthy discussion, and we have a motion pending for reconsideration of the BD email, which was not even to the court. It was an internal email with recommendations and observations, and that evidence was excluded. And so we have to object because now they're allowed to put an observation.
Mr. Winnie, you're misunderstanding what I'm saying. For purposes of refreshing someone's recollection, pretty much almost anything can be used.
Understood.
And if this, you'll call it a filing in the court file, if this filing helps refresh the witness's recollection, assuming she needs it, she might not need it.
Mm-hmm.
Assuming she needs it, then that's fine, but it's not being shown to the jury, it's not going to be referenced to the jury, it's just the document that she's using to refresh her recollection.
I understand.
So,
As long as they're not waving it around and keep it away until.
and Mr. Anderson, I mean, that's, you were making statements that Mr. Shapiro was waving the document around. I disagree with the characterization. Mr. Shapiro was standing at the lectern asking questions presumably from a document. He was not showing the document to the jury, and frankly, given how small the type is, and the distance from the lectern to the closest juror, even if he was holding it sideways, which he wasn't in the face of the jury, I don't think there's any reasonable belief that the jury would have been able to, with that much acuity, figure out what the words on that page were.
And I tend to agree with the court that unless we have falcons in the jury, they're not going to be able to spot that type. The one thing that I was concerned about, and I agree with virtually everything the court said, except he was holding a paper up here like this at the time that this started.
Standing at the lectern.
Standing at the lectern, but holding a piece of paper and obviously looking down, looking back up, looking down, looking back up. It does not take much to discern that this was some sort of official document, official report, because that's the way it was introduced. And so it appeared, to me at least, that he was holding it, reading off of it. He did set it down then, just for the record, and I think that that implies to the jury that there is some official document out there that this witness drew up or submitted to the court or to DCF, but in some way this was something official rather than for the use I understood he was starting out for.
Well, I think we just need to move on. I will give you time to discuss with your client and appellate counsel, so by the time we're finished with lunch today, I want to know whether you're moving for a mistrial or not, if you're asking for a further curative instruction or not, and what that is. If there's going to be a curative instruction, please get Mr. Altenburn and Mr. Elegant and Altenburn together on it, and we'll address it after we come back from lunch. Okay?
I have one more comment, and it's based on the allowable questioning that's coming. You were just a moment ago told there were 3 notes by Jessica Blackrick.
That's not what I said.
I'm sorry if that's not what you said. Well, I would object to questioning because there's 5 notes in total, and 4 of them were authored by Sharon O'Leary Johnson, who she just testified was the volunteer guardian ad litem, not Ms. Blackrick. So if he's going to be asking questions about personal observations at the hospital of Ms. Blackrick, fine, but I don't think it'd be proper to ask Ms. Blackrick to comment on what Sharon O'Leary observed in the hospital. If they want to call her in their case to have Ms. O'Leary Johnson comment about her observations, fine, but I don't think that's appropriate for this witness.
Well, I'm assuming we're not moving these notes in.
I'm not, but Miss O'Leary Johnson reports to Miss Blackrick, and these reports are filed with her. I believe I should be able to ask her, were these the observations of Miss O'Leary Johnson of Maya at the hospital as reported to you?
What is the hearsay exception that applies?
What's that? Well, she would sign off on these as her supervisor at the end of the case.
No. So, no, you can't. If you want to get, is it Miss O'Leary Johnson's observations, you can call her. Mm-hmm. Okay.
Then the observations of the child, then I'm going to be relatively brief with this witness, in this report are signed by her.
Who is her?
Miss Blackrick. Okay. And I'm trying to tread carefully without mentioning this is the report to the court.
Did this witness lay eyes on the child on, was it the 4th of January?
It was the 14th of October, Your Honor.
I think the note that I was looking at talked about January 4th.
The reports to the court, yes.
Oh.
Let's make it easy. You can ask about what this witness saw when she was in the hospital. But if someone else told her what that other witness saw, you can't ask this witness about what someone else told her what they saw.
Yeah, I understand that there'd be a way to get that testimony in through her, but I'd have to move the notes and evidence, which I can't do right now. So we might just do it through O'Leary Johnson. I understand, Your Honor.
The court will, maybe we ask at this point, although we'll need a curative instruction or the alternative, that at least at this point, that the jury be instructed to strike the question is stricken and any response should be, I don't want to draw more attention to it, Judge.
Well, that was exactly what I was thinking. I already told them to disregard the question, and I said it was not relevant to this case. I already said that, and that was immediate.
Yes.
If we're going to do something else, and I'm not saying we are, I'm just saying if, I only want to do it one more time.
Sure. Got it. I agree.
I don't want to keep doing 2 or 3 instructions on something.
In retrospect, I do agree with the court on that. I don't want to emphasize it anymore.
Okay. We ready to bring the jury back in?
1 minute, Your Honor, please.
Do you all need to take a couple minutes before to regroup? Mr. Sheehan?
If you don't mind. just-
Let's take a 5-minute break.
All rise, scores in recess. What do you got?
let's bring in the jury.
Yes, sir.
Yeah, I mean, you want that?
I've got the jury coming in.
All rise. Jurors entering.
Oh, get the witness back, please. Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information about this case. Is that correct? Correct. And that you have not been approached by anyone about this case. Is that correct? Correct. And that since you were last with us, you have not seen any media coverage about this case. Is that correct? Correct. Thank you very much.
If I may proceed, in Your Honor, my sincere apologies. I just have one more question for you at the bench. If I may. I don't have any further questions, Your Honor. Thank you.
When you went to the hospital, did Ms. Beatty ever introduce herself to you?
No, I never met her in person.
And so when you were there as the child's advocate, Ms. Beatty was not around?
Correct.
No further questions.
Any further questions?
No, Your Honor.
Members of the jury, do you have any questions? Okay. If the attorneys can approach. Okay. Members of the jury, most of the questions that you presented, I'm not going to be able to ask. But the question I can ask is, ma'am, the jury wants to know, was Miss Beatty always listening or included in all your calls between Maya Kowalski and Beata Kowalski?
Yes, sir. She was the point of contact for scheduling and facilitating the phone call to happen, and she was on it the entire time.
Okay, thank you. Mr. Anderson, anything further? Or sorry, Mr. Whitney, I apologize.
No, nothing further.
No, nothing further.
And may this witness be allowed to go back to Georgia?
She can, although we'd like to not fully release her in case we need her.
Okay, so the answer is yes, you can go back, but at some point you might have to come back. So, but the lawyers will be in contact with you about that, okay?
Okay, thank you.
Thank you. Have a safe drive back. And Mr. Anderson, Mr. Whitney, your next witness, please.
All right, Dr. Sally Smith by video deposition. There's 5.
Okay.
And just to inform the court, I'm told there's 5 different tapes. We'll have some breaks here.
Okay. Watch this. I did. How's that? Alexis, 20% down, 20% up? I went to school for that. Just don't ask me to turn it back on.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record.
Sally Marie Smith.
And you were a pediatrician working for the state in the case of Maya Kowalski. Is that true?
I was the medical director for the child protection team, providing a medical evaluation for Maya Kowalski, yes.
Following medical school, what did you do?
I did a pediatric residency. I did a 1.5 years of residency training at All Children's Hospital in St. Petersburg from 1984 to the middle of the end of 85. And then I transferred back to St. Louis University at Cardinal Glennon Children's Hospital, and I did the remaining 1.5 years of my pediatric residency there and completed that in 1987.
In your residency program, how long did you spend? And you rotate through a number of different areas, do you not, in your residency? All right. How long did you spend in pediatric psychology or psychiatry?
I, again, did not look at my transcripts before I came here. I really have no idea specifically. I'm sure we had training in pediatric psychology and psychiatry as part of multiple components of the residency program, but I don't specifically remember like how many weeks or if I did a specific rotation or something like that.
Okay. And do you remember any of your professors, or I guess they're doctors that are also adjunct to a medical school that you were working with? Or were you just, I'm trying to figure out the setup there. And my question really is, were there any doctors who are also professors that specialized in pediatric psychology or psychiatry that you worked with over this residency?
I don't recall.
Okay. Okay. After your residency, what did you do?
I did an additional year of fellowship training in ambulatory pediatrics at St. Louis University Cardinal Glennon Children's Hospital.
What is ambulatory pediatrics involved?
It was fellowship in, ambulatory is people who are not hospitalized, essentially. And so I worked in clinics with various mentors, learning to essentially teach academic pediatrics in the clinic setting. I don't recall that I did any specific inpatient work as well.
What is academic pediatrics?
Pediatrics that is sort of focused on education and training of medical students and residents and interns, and in many programs in academic medicine there are also research components to the work.
The past 17 years you've worked at Suncoast Center in one form or another, correct?
I don't believe so. I don't think that the Suncoast Center has held the Child Protection Team contract that entire time. There was another agency called Help a Child that held the contract from the Department of Health when I initially became the medical director. I've worked with the Child Protection Team since 1990.
Okay. So when it says medical director, Suncoast Center, Child Protection Team, were you working for Suncoast Center from 2002 to the present?
I've been the medical director of the Child Protection Team from November 2002 to the present. It probably should actually say Department of Health rather than Suncoast Center, because Suncoast Center is just the agency that holds the contract.
Okay. Well, Suncoast Center started at ACH in 1979, did it not?
No, that was the Child Protection Team, not the Suncoast Center. I'm going to guess it was around 2007, 2008 that the Suncoast Center took over the contract for the Child Protection Team, but I don't remember exactly when that was. I'm not sure, sort of what corporate name was, assigned or that kind of thing. When I worked with the Child Protection Team in 1990, it was, their signage and things said Suncoast Child Protection Team.
Okay. Well, when did you return to All Children's Hospital after, I think you were at University of Medicine and Dentistry of New Jersey, New Brunswick, New Jersey, from 88 to 90?
Correct.
And then you were back at All Children's Hospital, it says a staff appointment from 1990 to present?
No. Well, my active medical staff, yes, has been 1990 to the present. I was employed by the hospital from 1990 to 2002.
Okay.
In the general pediatrics division.
So you went residency for a period of time, then you left, then you came back and started with ACH?
In 1990, when I moved back to Florida, I took a faculty position with what was then All Children's Hospital, yes.
Okay. Would you agree with me then that you do not hold yourself out as an expert in pediatric psychiatry?
No, I do not.
Would you agree with me then that you do not hold yourself out as an expert in pediatric psychology?
I do not.
Would you agree with me then that you do not hold yourself out as an expert in pediatric neurology?
No.
You're agreeing with me.
I do not.
Would you agree with me that none of these, none of your training has involved an in-depth analysis of the diagnosis and treatment of RSD or complex regional pain syndrome?
I agree.
Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. You see that?
You're asking me if it says that?
In Maya Kowalski's case, was the medical director's opinion, was that you, or was there somebody above you, a medical director, whose opinion you could seek? Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. You see that?
Yes, I see it.
I mean, who's the medical director there?
That would be me.
Okay. And then the statewide medical director's opinion.
Yes.
Was that ever, in Maya Kowalski's case, did you ever seek the statewide medical director's opinion?
I did recently, but I don't recall if I did at the time of the evaluation or not.
Tell me about who that was recently or is recently and what opinion you sought.
Dr. Bruce McIntosh reviewed the file. And I didn't personally seek his response.
Let me find your report here real quick. Page 8?
Yes.
All right. So, Johns Hopkins All Children's electronic medical record. What does that mean?
Well, as an active medical staff member for Johns Hopkins All Children's Hospital, I have access to the electronic medical record. So I reviewed that, many documents from that medical record in compiling my report and reviewing the case. I did not print everything, so what you received of my medical records that have Johns Hopkins All Children's headings on them would be what Dr. McIntosh received.
All right, so Dr. McIntosh, according to you, received the medical records of Dr. Kirkpatrick, is that right?
Yes.
Dr. Hanna?
Yes.
Is that right? Dr. Barr? Is that right?
Yes.
Dr. Wassenauer? Is that
Yes.
right? He did not receive records from Dr. Chopra? Is that right?
Not to my knowledge.
Or Dr. Cantu?
I was never able to obtain records from Dr. Cantu, so I don't have them and did not have them to provide to him.
And so you were familiar with the fact that Doctors Hanna, Kirkpatrick, Barr, and Wassenauer all diagnosed or concurred with a diagnosis of complex regional pain syndrome, right?
That appears to be correct.
Tell the jury whether you believe that every mother that fails to remember to tell a new treating physician the entire medical history is committing an act of child abuse.
No.
Tell the jury whether you believe that every mother that fails to follow the directions of the doctor or the prescription to the letter is committing an act of child abuse.
No.
But in this case, you believe that Beata was.
Upon review of all of the extensive medical records, review of all of the observations of the child in the hospital, review of the, let's say, unconventional treatments, including hyperbaric oxygen treatment and high-dose ketamine treatment repeatedly, it was my opinion that there was ample evidence to support a diagnosis of medical child abuse, and it appeared most likely that Mrs. Kowalski was the primary one who was resulting in, or I don't know what the term is, it's not probably instigating, but initiating or whatever, the child abuse. Perpetrating the child abuse, let's put it that way.
Just the prednisone issues, the stuff we've been going over the last hour. Do you think that was an act of child abuse?
There was an element combined with everything else of child abuse in the prednisone utilization and administration to the child, yes.
Other than this case, have you ever testified in court or by deposition in a case involving CRPS?
No.
Expert in pain management?
No.
Okay. Did you ever have a conversation with Dr. Kirkpatrick at any time in 2016 in which he offered to have you come over to his office and he would demonstrate to you with Maya or with another patient the testing that could be done to objectively determine the degree of pain a patient was in?
No.
You never talked to him about that?
No.
Okay. Did you have a conversation with Dr. Kirkpatrick in which he told you not to move forward with Munchausen by proxy or another allegation of child abuse?
I do recall that he made some such recommendation to me. I don't recall the exact words.
Did he express to you that there was an organic basis for this child's pain?
I don't remember specifically that he, spelled that out. I remember, at least in general terms, that I asked him about incongruities in the child's presentation, and he reported that was a manifestation of allodynia prior to touch, conditioned to expected pain from human touch, and that there was a fear of pain component that explained the child's way that she was moving around and touching things and doing things, but then couldn't do those exact same maneuvers when a physician or a therapist asked her to do so, or things were touching her skin, and then when somebody had a light touch on her skin, that she would scream in pain when a similar amount of touch was not triggering that kind of response. So I remember that he and I had some discussion about that phenomenon. The fear of pain component can be explained, and therefore it was my impression that he was telling me that information as a way to indicate that there was no other possible diagnosis in the case, perhaps.
Would you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Did Dr. Kreisman, a physician at Johns Hopkins All Children's Hospital, examine Maya and note that she is not in any pain?
That was his assessment that day, yes.
And that she is not moaning, she is smiling, she is interactive, she is very engaged. Is that what he found? Is that what he found?
That's what he has documented in this note that references his examination of her when she was at his office on May 11th with her father.
And at the bottom of that narrative, he says extremities show no clubbing, right?
That is correct.
What is clubbing?
So that is an abnormality of the distal fingers, essentially the area of the fingernails where the nail bed gets enlarged, and the fingernails often have an enlarged size across the tip of the fingers, typically related to chronic hypoxia or respiratory insufficiency.
It's also a specific symptom of RSD, complex regional pain syndrome, is it not?
Not to my knowledge.
Okay. But you're not an expert in it, right?
I'm not an expert in complex regional pain syndrome.
And then he says she moved spontaneously in her wheelchair without incurring pain, right?
Yes, as was observed on other occasions.
Do you consider tachycardia to be an abnormality in a child this age?
It can reflect many, many different conditions in the child.
Well, what is tachycardia?
A fast heart rate.
Okay. In last deposition, you said that a fast heart rate would be an indication of somebody being in pain, right?
It could be.
But you put no abnormalities noted on her exam. That's not really true from the actual record, is it?
Again, you probably should ask the person who made the documentation. They may be referencing that contrary to most cases of complex regional pain syndrome, she did not have any color change of her extremities, sweating abnormality, deformity of her extremities that would provide objective evidence to support her reported diagnosis.
Let me show you what has been marked as Exhibit Dane.
Trying to find a date on this. 10/7.
And I'll reference you to, and I folded it over, the physical examination found on page 6 of 9, which is PLT 4074, and I highlighted under cardiovascular. Can you identify what that is first? What 15 is?
So this is the emergency center physician notes. I don't know, probably dictated by Dr. Bahar Posey in the emergency room. I'm sorry, what was the question?
Under the physical exam, does it note that under heart rate, she is tachycardic?
It does, and it states that her pulse rate was 134.
That's very high in a child of this age, is it not?
Well, 250 would be very high. It's elevated at 134.
Okay, that's not normal, is it?
Probably not.
Why did you put here in your report there were no abnormalities noted on her exam if she had an elevated heart rate that can be associated with a child in pain?
I don't know.
Okay. So if you've got, if she's tachycardic, if she has problems with her eyes from the light, if she has her knees flexed into the abdomen, if she has allodonia, meaning she doesn't want to be touched, and she has lesions, you've got 5 symptoms of RSD right there, do you not?
No.
Okay. You're saying allodynia is not a symptom of RSD?
It is.
You're saying that, what do you call it when you're light sensitive? You're saying that's not a symptom of RSD?
No, I'm saying she was wearing eye covers. Was she photosensitive? I have no idea.
Okay. She did not want to be touched.
That is correct.
That's a symptom of RSD.
It could be.
All right.
Could be a behavioral manifestation.
Okay. And she had a fast heart rate, right, which supports being in pain, does it not?
It could.
Knees are flexed up into the abdomen. That can be an indication, right?
That's a positional description. I don't know what that has, I don't know if that has anything to do with CRPS criteria. It certainly isn't Budapest criteria, to my knowledge, that positioning yourself with knees up to the chest is confirmatory objective evidence of CRPS. I'm there to evaluate whether there is evidence to support a diagnosis of medical child abuse. I'm not there to complete my evaluation unless I have to by saying, I don't know, this is all the information. It could be either, you decide. My task as the child abuse pediatrician is to evaluate all of the medical records, look for every piece of objective evidence that I can, evaluate all of the information in context, look at objective observations both in the presence and in the absence of the alleged perpetrator, and try to put all that information together to assess whether or not there's sufficient evidence to support a diagnosis of medical child abuse.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Doctor, this letter was faxed to your office on November 3rd, 2016, correct?
Yes, I think we established that.
Why did you not mention Eagle's Wings' history of treatment of Maya to the court on November 10th, 2016?
I don't know if I was asked about it or not.
How is it there is not a single mention of Eagle's Wings in your December 5th, 2016 report?
I don't know.
Again, your role and your stated goal was to be thorough, objective, and comprehensive in providing your report to the court, correct?
I provided this report in my role as the medical director for the child protection team. I believe it was eventually, presented to the court. At the time that I did this deposition, the report wasn't completed, so I don't know. I mean, I'd have to read the whole thing to see what, if any, discussion there was about Eagle's Wings Counseling Center in that. If somebody asked me about it or not, I don't know.
All right. Table 6.2, the last bullet point, recommendations for confirming infectious disorder by proxy. Consider covert video surveillance. Did you, in fact, consider covert video surveillance?
There was, I believe there was a day or so that there was some videotaping of the child in her hospital room in an attempt to document the amount of movement that she was and the activities that she was undergoing in her room when people weren't present or when doctors weren't present.
Who directed the video surveillance?
I guess I don't know. They have, a setup at the hospital.
Who directed the video surveillance?
I had discussion with the hospitalists. I don't remember exactly which one it was at that point in time about the possible benefit of that activity.
What did you find with the video surveillance?
There were numerous instances during the video which were comparable to numerous observations of the physical therapists, the nurses, the child life staff, the music therapy staff, etc., of the child moving around in bed, putting her feet in normal neutral position, using her upper body, her lower body in various movements that provided concrete evidence in support of all of the observations that were made by numerous hospital staff.
How does any of this indicate child abuse?
How does any of what?
The concrete evidence of her video of Maya Kowalski in her hospital room.
That was related to, she's 10. So as the children get older, there can be a component of the child having been sort of participating in the medical child abuse. One of the ways that this occurred in this case was that the child had very inconsistent patterns of movement and reports of pain in response to certain movements, and numerous other observations that were made by the hospital personnel. So this was an instance in which there was specific objective documentation that could be presented, if necessary, regarding what was being described and reported by numerous treating providers at the hospital.
How much involvement did you have in Maya's care from the time of her admission throughout her sheltering at Johns Hopkins?
So as of October 13th, you mean? I talked to several physicians. I think we've talked about that already. I reviewed information as I was preparing my report.
And beyond October 13th, up until the time of your report, how much involvement did you have in her care?
I was not a treating physician.
That's not my question. How much involvement did you have in her care?
I had conversations with some doctors.
Did you direct any actions?
I had discussion with several doctors at various points in time regarding things that could be considered to improve Maya's safety and her and the effort to have her have a more effective separation from her mother. There were a lot of times when she was Skyping with her mother, even though she was sheltered in the hospital, and so there were some discussions related to ways to minimize effects on her safety related to that.
Beyond discussions, did you direct any actions?
I don't believe so specifically, no.
Did the hospital look to you for direction?
I had discussions with several treating physicians at points along the way while she was admitted.
All right, let's look at what we'll mark as Exhibit 7. Dr. Smith, this is 2 sets of text messages between yourself and Dr. Major and Dr. Deese. So let's turn to the 3rd page of the exhibit. And these were produced from your phone, correct, Dr. Smith?
Yes.
To orient the jury, as we look down through these text messages, we see, for example, in the 2nd text message, reply from SS. Who would SS be?
Me.
And reply from PD. Who would PD be?
Paula Deese.
Okay. So you have her number in your phone?
Yes.
She's a saved contact?
I believe so.
Okay. Let's look at the 2nd text from the bottom. This is a text from you to Paula Deese where you state, "We may need to try to monitor what she's doing online. I wouldn't put anything past her mother."
I'm sorry, where are we?
Page 1 of your text messages.
Oh, okay.
So when you called Cindy, what did you learn?
I don't know.
No independent recollection?
I went there and I talked to some people. I don't know if Cindy was one of them. And I vaguely recall looking at some of the stuff. I know we had some discussion about what they had seen and what they had captured on the video in terms of whether I really looked at any long review of that. I don't believe I did, but I think that I did have a discussion with the people in that office about what they had observed, which, as I said earlier, was essentially documentation of many of the things that were being observed by the physical therapy, occupational therapy staff, child life, music therapy, in terms of inconsistencies about what Maya said she could do, and the pain that actions would cause, and what she would do when she was just acting on her own without somebody asking her to do something.
Doctor, do you also intermingle the professional life and personal life in your personal email address?
I don't use email related to patient care. I do receive email from, for example, the medical staff office on my personal email.
Okay. the medical staff office of whom?
Johns Hopkins All Children's Hospital.
All right, Doctor, we've spent some time discussing your use of different devices and technology. I'd like to direct your attention now back to the text messages. As previously marked as an exhibit, the response to the fifth request for production from August 30th, 2019. And I'm on what's at the bottom, page 2 of these text messages. There's a message from October 21st, 2016 at 12:50 from you, doctor, to Dr. Deese. It says, "Hey there, just a few things about Maya. Do you have a minute for me to call?" Do you recall what you wanted to discuss regarding Maya on October 21st, 2016?
No.
Do you recall how long the call was?
No.
You were in close contact with the hospitalist, Paula Deese?
I had a number of communications with her during the time that the child was in the hospital.
All right, it looks like an hour and 9 minutes later at 13:59, perhaps after discussion, you write, "Also, probably already in progress, but maybe get her off as many meds as possible." You're suggesting action to the hospitalist on the case at this point?
We were discussing elements of the case and the care.
Do you agree with the characterization that you're suggesting action on the part of the hospitalist?
As it says, I texted to her, probably already in progress, but maybe get her off as many meds as possible.
Would you agree that's a suggestion to the hospitalist?
That was part of our text discussion regarding recommendations. So I guess it was a suggestion. I don't know in what context.
And it's a suggestion related to Maya's medications while she's sheltered at Johns Hopkins, correct?
I believe I just read exactly what it says.
Do you agree with that characterization? It's a suggestion related to Maya's medications while she's at Johns Hopkins.
It was apparently a proposal related to her medications.
Is the decision whether or not to take Maya off of medications an evaluation?
As a child abuse pediatrician that provides assistance to many doctors at Johns Hopkins All Children's Hospital, I sometimes discuss with them testing or treatments or things like that that may be helpful for either the child's well-being or for some element of my evaluation or things like that. In my view, the things that you're talking about here were discussions that I had with a couple treating physicians on a few occasions related to things that would improve my safety and assist in minimizing the effects of the medical child abuse.
Were they treatment decisions? Removing from medication. Is that a treatment decision?
That was just a discussion that I had with the treating physician in terms of whether or not she, how she responded to my discussion or recommendations or suggestions to her. That's up to the treating physician.
Is removal of someone from medication a treating decision?
If I had gone in and written the orders myself and directed exactly when a dose was decreased and what medication was discontinued when and things like that, those would be treating decisions. Having a discussion with this physician about a child that we were both providing medical care for and medical evaluation for is not, in my view, a situation in which I was providing treatment for the child.
So a treating decision is only made by the person that undersigns a particular progress note and not by the team that consults in making that treating decision?
All of these things, we've talked about were something I said maybe, something I said consider, are you doing this, things like that. So I'm not directing them to do specific treatment. For example, with the removal of medications, that had already been ongoing and mostly completed when I asked the question. So clearly that wasn't based on something I told them to do. That was based on all of the treating physicians at the hospital, the pain management team, the hospitalists, and whoever. I said something about maybe get her off as many meds as possible. Yep, last med coming off today. So it's not like 7 minutes later, they had removed all of her medications based on my recommendation.
My question is very simple. Is removing medications from someone a treating decision? Yes or no?
I don't know.
You don't know if removing someone from medications is a treating decision?
You know, it depends on all the circumstances and stuff in terms of whether that would be considered treating and, you know, that kind of thing. I mean, certainly that would be one thing that a treating physician might do.
Doctor, raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Has your position insofar or role with Johns Hopkins All Children's Hospital changed in any way?
I continue to be a member of the active medical staff. That's my only relationship with Johns Hopkins All Children's Hospital. I don't really know anything about how people at the hospital have some sort of employment or relationship or title or anything.
Who would you say was the person that you had the most contact with during the period of Maya's placement at Johns Hopkins All Children's Hospital? Which doctor? Would it be Michelle Smith? I mean, who would it be? Tepa Sanchez? Would it be Malik Farad? Who would it be?
My recollection, I spoke to Dr. Tepa Sanchez about the child once. I spoke to Dr. Vos about the child either once or twice. I never spoke to Dr. Malik.
After Beata's suicide, did you receive a call, text, or any other communication from Dr. Major?
Dr. Major and I exchanged a few text messages on January 9th and January 10th of 2017, all of which I believe have been previously produced for you.
I'm wondering, when was the last time you worked on a committee other than the credentialing committee?
I was, most of the committees that I was on, I left in 2004 when I left my employment with the hospital. I was a community pediatrician representative to the medical staff executive committee from July 2011 to January of 2016. Since January of 2016, the only committee at All Children's that I've served on is the Standards and Credentials Committee.
And for your work training residents and interns and otherwise consulting, how are you compensated?
I'm not. I'm a volunteer.
How many hours a week would you say that you devote to training Johns Hopkins residents, interns, and doctors?
Personally, close to zero. They primarily work with the nurse practitioners with our team.
Under you?
I supervise them, yes.
Without naming any names, can you give us some examples of the type of consulting you've been doing? I mean, what, is it a broken leg? Is it fever? Is it a child with, hysterics? What kind of situations can you think of that you provide consultation?
With the residents and the medical students?
Right, or the doctors.
Well, residents are doctors.
Granted, but
it's very random. So the children that come here are coming here for medical evaluation for alleged child abuse or neglect. If I'm here and I'm available and the nurse practitioner has seen an interesting child with them or might have a question about a child that they've seen and wants me to help review with them to guide them, then if the resident happens to be present, they might hear the discussion that we have. I would say over the 10 or 15 years, on maybe a few occasions, I've recognized a resident that was here who I might have seen or I knew was involved with a child that I saw at the hospital, and we might discuss that child in more detail. But that's happened maybe less than a half dozen times over the last 10 years.
Now, let me ask you about the credentialing committee. Is that who determines who can strike it? What kind of credentials are you talking about there?
So anyone who is providing medical care at the hospital or in the outpatient setting in some circumstances has to be approved based on their credentials. Standards and credentials committees are standard at medical facilities, and that committee reviews resumes and recommendations and lists of procedures performed. We used to interview the people who were applying for privileges, but that's changed over the years, and now we only occasionally do direct interviewing. Then the committee makes a recommendation to the medical executive committee about whether a person who is applying for privileges with the hospital should be approved. Then the medical executive committee in turn presents the information to the board of trustees for approval.
Thank you. So this is what would be known as privileges? Is that the same thing?
These are people who are applying for practicing privileges at the hospital.
So when a doctor says, I've got privileges at that hospital, this is what you're approving?
We're reviewing their information and making a recommendation to the next step as I went through.
Does that mean yes? Colloquially, when a doctor says, I have privileges somewhere, if they want to have privileges at Johns Hopkins, your committee is one of the hoops they jump through?
They have been presumably vetted by our committee, and a recommendation to approve staff privileges has been made.
All right, let's start off with the employment. At the time that you rendered services for the medical protection team, who were you employed by back in 2016 and 2017?
At that time, as the medical director of the child protection team, I was employed by, Suncoast Center Incorporated and the state of Florida Department of Health.
Okay. Were you employed by Johns Hopkins All Children's Hospital during that interval of time?
No.
Specifically, plaintiffs have indicated that you completed your residency at Johns Hopkins All Children's Hospital. Is that true?
At the time that I was in the residency program from July of 1984 until the end of December of 1985, it was just called All Children's Hospital. It was not affiliated with Johns Hopkins.
Okay. All right. Let's start off with the employment. At the time that you rendered services for the medical protection team, who were you employed by back in 2016 and 2017? And in briefing, I believe there's also a claim that you took a faculty position at Johns Hopkins All Children's Hospital. Is that true?
No, again, I worked for All Children's Hospital, not affiliated with Johns Hopkins in any way, from 1990 until, from July of 1990 until, I believe, November of 2002.
Have you ever been employed by Johns Hopkins All Children's Hospital?
No.
Any claim to the contrary would be untrue?
Correct.
How does it work? It seems like from what you've testified previously that you were medical director of the Child Protective Team, but that you were both employed by Suncoast and Department of Health. Can you kind of explain that dual employment arrangement?
Yeah, so as the medical director of a child protection team, I received direct compensation from the Department of Health for some components of my responsibilities. Typically, that has been about 17 and a half hours per week for the last, 10 or 15 years. The Suncoast Center Incorporated holds the contract for the Pinellas County Child Protection Team. I believe they have done so since 2008. And so, in addition to the direct compensation that I get from the Department of Health, I also am in the role of the medical director for the Child Protection Team under Suncoast Center.
Over the years, my understanding is you've served on some committees with both All Children's Hospital and later Johns Hopkins All Children's Hospital. Is that correct?
Yes.
Okay. And pertaining to the times that Johns Hopkins All Children's Hospital strike that, were you ever compensated by Johns Hopkins All Children's Hospital for any committee service?
No. Back when I worked for the hospital, obviously I was participating in committees during time frame that I was, an employee. But since November of 2002, I have not received any compensation of any sort for being on any committees.
Okay. So it's fair to say since around approximately the turn of the millennia, you have not been employed by All Children's Hospital?
Not since November 2002.
This Fifth Avenue Pediatrics listed on your CV from March 2003 to the present. What is Fifth Avenue Pediatrics?
That's the current name for the private practice that I'm a partner in.
Is that private practice affiliated in any way with Johns Hopkins All Children's Hospital?
No.
My understanding is you were first contacted by a Johns Hopkins All Children's Hospital physician in this case on or about October 8 of 2016. Do you recall that conversation?
Generally, yes.
At the time that you were reached out to by Dr. Tepa Sanchez, were you receiving that call as an independent medical staff position?
If I understand the terminology correctly, yes.
Okay. Well, why don't you explain the difference between when you get involved in a case as a CPT versus if a doctor who needs a consult just contacts you?
Well, technically the child protection team can be involved in a case if there is a report to the abuse hotline and either an investigator with Child Protective Investigations or law enforcement requests for us to provide a medical evaluation. There are some cases over the many years I've been involved with All Children's and now Johns Hopkins All Children's where that may or may not have occurred as yet, but a physician knowing my expertise in child abuse pediatrics and my capacity as an active member of the medical staff will contact me directly to ask questions about a case that they are seeing and seeking some guidance about whether or not there may or may not be abuse or neglect in the case.
Is there anything wrong or unethical about a physician who has suspicions reaching out to a child abuse pediatric such as yourself for some insight?
I can't imagine why there would be. For example, if somebody, if a doctor thinks that a child might have a heart problem, but they don't know exactly how to proceed with further pursuing that, they wouldn't be unethical to consult a cardiologist that's on the active medical staff for guidance. I think consulting an active medical staff member with expertise in child abuse pediatrics, in my view, would be the same thing.
Is it fair to say that when you were rendering services to in this case, that you were exercising your independent professional judgment?
Yes.
I guess my first question for you is, did you have a customary practice back in October 2016 and into 2017 as to how you would introduce yourself to a family where you're doing a CPT investigation?
Yes, I would state that I was Dr. Sally Smith and I'm a pediatrician with the child protection team.
Do you recall doing that with Beata Kowalski?
Yes, I've testified in depositions before that Mrs. Kowalski knew exactly who I was. The timing of the meeting with her, et cetera, was arranged a little bit ahead of time so that I knew she would be there and she knew I would be there. And I believe there were people from Protective Investigations that were present during the interview.
Do you actually recall introducing yourself as the medical director of the child protection team to Beata Kowalski?
Yes, I do.
Okay. And do you recall the same with respect to Jack Kowalski?
Yes.
You introduced yourself at that time as the medical director of the child protection team?
I may have introduced myself as a pediatrician with the child protection team. I don't know for sure that I said specifically medical director.
Sure. But you would have said something about your role with the child protection team?
Absolutely.
Earlier this year. Did you ever represent to Maya Kowalski that you worked for All Children's Hospital?
No.
Did you ever represent to Beata Kowalski that you worked for Johns Hopkins All Children's Hospital?
No.
Did you ever indicate to Jack Kowalski that you worked for Johns Hopkins All Children's Hospital?
No.
Did you ever prescribe medication for Maya Kowalski?
No.
Did you ever enter a progress note in Maya Kowalski's medical chart?
No.
Okay, to the best of your recollection, were you wearing a white lab coat with Johns Hopkins insignia on it when you met Maya Kowalski?
I don't have and have never had a lab coat with the Johns Hopkins insignia on it. I definitely wasn't wearing any such thing when I saw Maya Kowalski on either of the two occasions that I saw her.
Did you direct anybody with respect to Maya Kowalski's care and treatment at Johns Hopkins All Children's Hospital?
In the course of her hospital stay, there were times that I spoke with, I believe, Dr. Deese and Dr. Major with regard to the issue of medical child abuse and some things that could be considered in terms of demonstrations of movements that she was making that weren't consistent with the reported diagnosis of RDS, or what they're calling now complex regional pain syndrome. I had discussions with people about her course in the hospital, but I never was directing any treatment for her.
When you're working as, the medical director of the child protection team for Pinellas County, is it common for you to discuss aspects of a patient with the patient's treating providers?
Yes.
And to your knowledge, did Johns Hopkins All Children's Hospital ever hold you out as Johns Hopkins employee or agent while you were rendering services as the medical director of the child protection team in Pinellas County?
No.
Okay. And at some point, I understand you talked to a Dr. Anthony Kirkpatrick. Do you recall doing that?
Yes.
What do you recall about the conversations you had with Dr. Kirkpatrick? Generally speaking.
So what I recall was that I think he called and left a message, and I called him back, and the one thing I definitely remember was that he told me that I should not evaluate the child for Munchausen syndrome by proxy because that was not a problem in the case.
Okay. And did you consider his advice?
Well, I certainly heard him, but if I had heeded his recommendation, I would not have been doing my job. And
What do you mean by that?
well, my job in this case was to respond to the request from the investigators and law enforcement as to whether there was medical evidence of child abuse or neglect in the case. And the only way to do that when the concern is Munchausen syndrome by proxy or medical child abuse is to gather extensive medical records as much as one can, review all of those medical records, put that in the context of information that may be directly obtained, such as the information I got directly from Beata. Ordinarily, one would consider one's physical exam, but in this case, I was unable to conduct a physical exam on the child, and then put all that information together to try to determine whether there's medical evidence of child abuse. So if on October 11th or 12th, or 13th, when I spoke to Dr. Kirkpatrick, I had just said, oh, Dr. Kirkpatrick says there's no Munchausen syndrome by proxy here, so there must not be, I would not have been doing my job.
Do you know who Dr. James Lewis is?
Yes.
Who is he?
He's a neuropsychologist. At the time Maya was admitted to the hospital, he was a consulting neuropsychologist for the child protection team, and he provided a neuropsychological evaluation of her as part of the evaluation under the child protection team.
And he's not a medical doctor, is he?
No.
I believe he's a PhD.
Correct.
Is it common for people like Dr. Lewis to perform a psychological evaluation of a child who's the subject or whose parents are the subject of an ongoing investigation?
He was doing so probably about 20 or 25 times per year at that time.
Well, do you know who he was employed by back when he consulted with Maya Kowalski?
He was contracted with the child protection team, and so when he would provide a neuropsychological evaluation for a child who had been, referred to the team for assessment, I believe he would just submit a fee-for-service type invoice or something to Suncoast Center.
To your knowledge, was he employed by Johns Hopkins All Children's Hospital?
To my knowledge, he was not.
Other than the grand rounds that you've discussed, do you have any evidence that you received any compensation from Johns Hopkins All Children's Hospital?
I have not. Case.
Well, that you were you never even told her that you were investigating her for allegations that she committed child abuse, did you?
Well, based on Mr. Hughes's report of her email, I think we could, have a discussion of what she understood about what I was doing. But
no, this is about you.
I introduced myself as a pediatrician with the child protection team. I did not go into major detail about what that meant.
And you did not do that with Jack Kowalski, did you? In that first interview with him, let me finish my question. In that first interview with him, you did not tell him that you were investigating him for possible allegations under allegations of child abuse of Maya, did you?
I introduced myself as with the child protection team. I did not go into detail about what that meant.
And you did not tell Maya Kowalski in your version that you were investigating her parents for child abuse, did you?
I was taking a medical history from the people in terms of instructing them about that I was an investigator or something. I did not do that.
Just out of curiosity, what were you wearing when you interviewed the Kowalskis?
Business casual street clothes and ID badge.
Well, okay. And what does the ID badge say on it? Does it have your name?
Yes.
And it has Johns Hopkins on it.
It has a logo for the hospital as an ID badge would.
And what field of expertise did you hold at the time that Dr. Tefa Sanchez contacted you on October 8th?
Child abuse pediatrics.
Okay, and you had active staff privileges on October 8th?
I did.
You had privileges at Johns Hopkins?
Yes.
Is that the last one?
Yes, Your Honor.
I'm so proud.
I'm so proud of myself. Can I see the attorneys for just a moment, please? Okay, members of the jury, I mean, you probably figured out what we were doing. Just trying to figure out timing and lunch. And it probably is best that we don't start. So what that means is, why don't we take lunch now? I'm going to ask that you be back and ready to go, Deputy Coley, at 1 p.m. So about an hour and 35 minutes. So do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Okay, thank you. The jury's out of our presence. Everyone can be seated. Why don't we come back at 12:40, which is an hour and 15 minutes from now. That'll give us 20 minutes to discuss whatever we need to discuss.
Judge, can I raise one quick issue, or do you have to go?
Hopefully it's quick.
Well, Judge, in reviewing the video for Dr. Neuberger, I didn't actually watch the video. I just read what they said was on the video words. I'm not anticipating any exhibits coming up, and I just need to find out, are they going to be flashing pleadings or things during the video? Because I didn't watch it. I took their word that this was what was on the video.
And I saw that in Dr. Smith's, a couple of them, we did cover up whatever was being shown to her at the time. So.
One was a pleading. But in any event, that's my question. Is it just the doctor, or are they going to be flashing up documents? Because I didn't watch the video. I didn't think that was necessary.
I haven't had time to watch it myself, but I'd suggest, is that solution acceptable, that we cover things that come up on the screen momentarily? That box?
Quicker.
Look, if there's going to be something that is not in evidence, it absolutely needs to be covered, or somehow not shown to the jury.
I understand.
I've watched part of it and read the transcript.
I've just said what has to happen. I trust that directive is going to be taken care of.
Judge, as to the Sally Smith video, at approximately 111 minutes, 10 seconds, there was a response by Sally Smith where she said, and we had objected to this, she was responding to a law enforcement request that she conduct an investigation. So that is flat out true, and there's absolutely no evidence in this record that Dr. Smith was ever contacted and assigned by the police department or the sheriff's department or anyone else. And so we would like an instruction that although the question and answer were allowed, there's no evidence in this record that Sally Smith was acting on behalf of the Sarasota County Sheriff's Department or anyone else.
Well, hold on a second. Wasn't the testimony, if she get a referral from the hotline or law enforcement, I think was what the...
It was an alternative.
I don't recall her saying in this particular case that law enforcement requested her.
I will double check the transcript. Maybe I heard incorrectly.
Let's double check, because I think there was an or, and I did not, sitting here, I didn't get the perception that any law enforcement requested her.
We just want to make sure, of course, that the jury doesn't get the idea that she was under there for any particular tasking by the Sheriff's Department, the State Attorney's Office, or anything else. The only other thing at this point we wanted to just start out, we can talk about it later, is that...
If we're going to talk about it later, let's not talk about it now.
Okay.
What time do we need to be back, Judge?
Let's be back at 12:40.
12:40. Thank you.
Thank you very much. Now, hold on a second. When I say let's talk about it later, is this some sort of motion that's already been filed that I need to be ready to go on, or is this the issue that was from this morning?
It's an issue that just came up this morning.
That issue, let's
on it, but we have not filed a memorandum on it. It came up through the course of Sally Smith's deposition, but I can present the motion. It's an ora tennis motion to conform the pleadings to the proof in this case.
Well, why don't we'll deal with that one later.
Yes, sir.
Thank you.
All rise. This court is at recess.